Thank you all, and good morning. Welcome to this panel on intersectional stratification, structure, violence, and cross-movement politics. My name is Carole Goldberg. I'm a member of the UCLA Law School faculty and proud to be one of the founding members of the Critical Race Studies program here at UCLA. We have a wonderful panel for you today. It's going to be focusing on the structural mechanisms and forms of discourse that maintain intersectional vulnerabilities, especially to violence. One of the things that has been very striking to me in looking at the work of these panelists is that intersectionality offers a critique, certainly, of current mechanisms and understandings of stratification and subordination, but that understanding also affords opportunities and possibilities for activism, for various forms of legal challenge that can prove exceedingly productive. And I think you're going to see from these panelists today both the understanding that comes from critique and the sense of possibility and opportunity that that understanding affords. I'm going to introduce the speakers in the order from which you will hear them, and then I will simply bring them forward or have them speak at the table as they wish when their time is coming along. So our first speaker is going to be Beth Richie. Beth Richie comes to us from my hometown of Chicago, Illinois, where she is the head of the African American Studies Department at the University of Illinois at Chicago, and also the director of the Institute for Research on Race and Public Policy. I gather this is something new, but what isn't new is her prominence in the field, and among the many works that she has published is a book, Compelled to Crime, The Gender Entrapment of Battered Black Women. And she is going to start us off this morning with a broad perspective on intersectionality and its work in understanding the anti-violence activity that's been taking place in anti-prison movements. Our next speaker is Tanya Hernandez. Oh, excuse me. Our next speaker is going to be Sarah Deer. I got to get that order correct. Sarah is somebody who I've known for quite some time. Sarah is a member of the Muskogee Creek Nation. She is a professor at William Mitchell College of Law, and she is a very prominent writer in the area of violence against Native women. She worked closely with Amnesty International in the production of their report on that subject. She's also done some teaching for our program at UCLA, our Tribal Learning Community and Educational Exchange Program, because of her work on tribal law. So welcome, Sarah. Our third speaker is Tanya Hernandez, who comes to us from Fordham Law School in New York, where she has been doing some really fascinating empirical research on sexual harassment and intersectionality, and I understand that several of her articles are posted on the CRS website for you to examine. She has recently been elected to the very prestigious American Law Institute, and this is not her first time at UCLA. We heard her speak just pretty recently, and it's always an enriching experience to do that. Our fourth speaker is coming the furthest distance. Mieke Verloo comes to us from several affiliations at Radboud University in the Netherlands. I may not have gotten that pronunciation correct. But she is affiliated there with the Faculty of Management and also with the Institute for Gender Studies. And she is going to be speaking to us today about cross-movement coalitions that are facilitated by an intersectional understanding. And I think that will be very valuable for us to hear today. And our final speaker is Lenora Lapidus, who comes to us also from New York, where she is the director of the Women's Rights Project of the ACLU. And she has been long engaged in litigation of constitutional and other discrimination cases involving gender discrimination and other areas. She does public policy advocacy, and she is going to be giving us the advantage of her practitioner's perspective, looking, among other things, at family separation policies that affect poor women of color, and the linkages of those policies to the war on drugs. She's also going to be helping us understand distinctions between a human rights and a civil rights approach to these issues. So we have a very rich array of speakers today. Each one is going to be speaking for approximately 20 minutes, and we are looking forward to some opportunity for exchange with this audience that we have today, practically standing room only, and we're very appreciative of that. So without further ado, let me introduce Beth Richie.
Good morning. I want to begin with a huge thank you to UCLA Law School and to the Critical Race Studies program, and in particular take a moment to really appreciate people who probably aren't in the room now, because they're doing all of this incredible work to make this a seemingly seamless conference. And as someone who, like many of you, sort of traveled, not as far as others, but I traveled a long way, didn't get my stuff in on time, was rushing around, where am I supposed to be, who's going to be what? The people who have staffed this conference have been just extraordinary. So a shout out to them. And chairs just appear when people need them. It's really pretty amazing. Thank you. And then, of course, Kimberly, a huge thank you to you. I was thrilled to be invited to be on this plenary, in part because I get to see you and so many other old friends. It felt like I was coming to a kind of intersectionality family reunion, if you will, and that I knew that there'd be like new cousins here and new people to meet. And I was really grateful to be asked to be especially part of this panel because the title of it, Intersectional Stratification, Structure, and Violence, at least the first title, made me feel like I would have this chance to testify about how important intersectionality has been to my work as a black feminist activist working against violence against women. And then I looked ahead and saw the second part of the title, Cross-Movement Politics, and a sense of trouble sort of set in, dampening my enthusiasm a bit, not about the people, not about coming to UCLA, but about the work. So in preparing my comments, I'm going to talk a little bit more about the ways that I've been disappointed, but I want you to know that that disappointment comes in great part because of my high expectations of what we could have done, maybe what we can still do, using intersectionality to not only talk about violence against women, but in fact enhance our cross-movement politics. I'm going to give you a bit of context for where that enthusiasm and disappointment comes from, and share some stories that I think illustrate my point. This year marked several important anniversaries to me as a black feminist activist working against violence against women, embracing intersectionality and critical race theory. It was almost 25 years ago, a little bit more than 25 years ago, that I was a group of women of color working in New York City to start one of the first community-based anti-violence programs in the city for women of color in Harlem, a predominantly black and Latino community in the city, which of course is renowned for the history of political and cultural activism. And perhaps naively, that context led us to expect that people there would be open to our feminisms of color and our responses to the gender-specific dimensions of the problems that we're facing the community in terms of health and well-being. We were surprised to find ourselves, Kimberly, you'll remember this, surprised to find ourselves engaged in struggle with male leadership and male-identified leadership that many women had, all people of color, who resisted our attempt to intervene in what we thought to be serious, not just problems, but problematic politics around questions of gender and sexuality. It was the same year that I went to my first conference of the National Coalition Against Domestic Violence in Milwaukee, Wisconsin. I was energized by the dynamic feminist activists who were building the social change movement in this country to take on the question of violence against women. In particular, their analysis of gender inequality deeply resonated with the work that we were doing in Harlem, except, of course, for the emerging white feminist analysis that did not adequately incorporate understanding of race and class inequality. I was introduced at that time to the Women of Color Institute and the broader national movement of women of color who were feminist activists, where a more intersectional analysis of the problem prevailed. Now, this wasn't because people had read about intersectionality. This is because the reality of our work on the ground in communities of color working on violence against women, consistent with our everyday experience, meant that we had to take on the issues of race and class and sexuality if we were going to be part of this work. It meant that almost immediately we were challenging white dominated groups to relinquish their hold on the growing resource base and their subsequent power. And we were also challenged to take on the patriarchal assumptions in communities of color about what problems were and what solutions might be. It was, for me, a very exciting time to be a community activist, to be coming into feminist consciousness, and the anti-violence movement at that time served as a stimulating environment for my feminist anti-racist practice, in great part because we were deploying, embracing, using a intersectional analysis. Over the years, as that work changed, we tried to stay committed to the stories of women of color among us who were battered, raped, stalked, kidnapped, harassed, humiliated, and degraded by individual people in the community, as well as attending to state-operated systems of domination. We didn't know how to do our work in any other way. We were passionate about the work, profoundly disappointed in the other organizations that we found around us, but we stayed true to our commitment because we were listening to women's stories and sharing our own stories to end violence against women, particularly women of color, in a way that made sense for us. Again, we thought that the conditions were ripe for autonomous black feminist organizing. We expected to find all of these natural allies who simply weren't there. Over the last 25 years, the white feminist anti-violence movement has become more entrenched in overly simplified gender analyses, and male-dominated organizations in some communities of color continue to persistently reject the notions of gender inequality and why feminism has any relevance for women of color. Despite what I think are important examples, which I won't take time to note, I just will note that there are some important examples of a different narrative. The relationship between white supremacy, class exploitation, heteropatriarchy, and gender inequality continue to be absent from the places where they need to be taken up seriously. And I continue to feel a very strong tension, in fact, maybe even a stronger tension in political and cultural spaces where theories of race, class, gender, and oppression clash, particularly in the U.S.-based anti-violence movement and anti-prison movement. The tension for me has escalated in the last 10 years as a new political paradigm has emerged, a paradigm that many of us are calling the buildup of a prison nation. I give a special shout out here to Insight, many of whose original members are at this conference, because it was 10 years ago when we began to, as anti-violence activists, immerse ourselves in the work to end the prison industrial complex in this country. The notion of a prison nation reflects the ideological and public policy shifts that have led to the increased criminalization and disenfranchisement in communities of color. This includes, of course, more aggressive law enforcement strategies for norm-violating behavior, undermining of civil and human rights of marginalized groups, etc. most intellectual and political responses to this buildup look at how these developments disadvantage men, particularly black men, while alongside the white feminist anti-violence movement has increasingly focused on white middle-class women. Now, there's a more complicated analysis of this, including that there, for some women, have been some benefits to the ideological shifts associated with the buildup of prison nation. There probably are some women who would claim to be much safer now in 2010 than they were 25 years ago. There's been important activism in the anti-prison movement that has led to the release of prisoners as well as a new understanding of how damaging the conservative law and order agenda is. But I will argue that because these two movements haven't talked to each other, there are some women, precisely women whose lives intersect those movements, who are in as much danger as ever. Let me give you 3 stories to illustrate that point. The first story took place on a morning in Chicago, a bright, sunny spring morning, where I was driving by a high school not far from my home and saw a presence of news cameras surrounding a trash dumpster in the back of the school. I stopped. It just seemed like such an odd representation of people in this, gathered in this community. It took me a few minutes to realize what was going on, and as I was talking to one of the reporters, I realized that there was a young woman who was 15, pregnant. She found herself in the stall of the bathroom at her high school, obviously desperate and frightened, trying to figure out what to do. She delivered the baby by herself, put the newborn in the backpack, and placed the backpack in the dumpster behind her South Side Chicago high school. So this raised the question for me, again, not as an anti-violence activist yet, not as an anti-prison activist yet, but as a person who lived in the neighborhood. How could anyone feel so desperate? Who was this young woman? How could these events have been only covered by the news media? Where was the community? Where was her family? The story actually ended up to be cast as a story about the heroic discovery that the reporters make because there was a trash collector strike in the city of Chicago. No one talked about her teachers who were alienated from their work as public school educators, socially distant from the children they taught, her parents who were distracted by the pressures of negotiating a large extended family's needs with insufficient resources, a group of friends who couldn't attend to the dilemmas that she faced. In a matter of hours, the story became, at least according to the local news coverage, the story of the discovery of a newborn who died tragically in a dumpster and the heroic work of the reporters and this trash collector's strike. Of course, all of this was supported by stereotypic images and quick soundbite judgments of an irresponsible, ruthless, brutal, uncaring young black woman whose behavior was completely understandable because of the institutional disregard for her and the ways that the general conceptions of young women of color's image and behavior in contemporary society is shaped by factors associated not only with anti-violence rhetoric of who's a victim of violence, but also the dynamics of a prison nation. Indeed, I argue that the image of her flourished because the image of an irresponsible black woman, because no family member, no friend, no advocate, no official representative of the state or no reporter took a minute to find out anything about her life, anything about the violence that she had been experiencing from her uncle for the past 2 years, the repeated rapes, or her boyfriend's constant surveillance as the abusive behavior that it was. It was clearly attributed to her marginal position, not only in her community, but her community's marginalized position in the city, and her marginalized position in her family and her social network that led to this tragic consequence. I'm calling this young woman Tanya. Her story is important both in the real and metaphorical sense because of the conditions that she lived in, the ways that her experience was not attended to by the movements that I was a part of, and the ways that conservative public policy virtually locked her into desperate circumstances. Not far from where Tanya lived, just 9 blocks south, in fact, 3 weeks later, a woman named Ms. B was watching television in her small apartment and heard a loud knock on the door. When she opened it hesitantly, she was pushed against the wall and forced into her living room, where 5 men, undercover Chicago police officers, began to ransack through her apartment and destroy her property. Ms. B knew immediately who these men were, even though she could barely see them, because it was only the most recent of a series of violent attacks. Ms. B was first attacked outside of her apartment in a large public housing complex where she had lived for 27 years, Chicago Department of Housing. Paradoxically, this was one of the sites that was identified by the Plan for Transformation, as the city of Chicago calls it, to tear down public housing in her neighborhood. Associated with the decision to tear down public housing, of course, were other public policy decisions, suspending services in the neighborhood, increased police surveillance, and advancing a kind of public relations campaign to homeowners in neighboring communities about how this would advantage them if we destroyed public housing. The initial attack was facilitated by this barren landscape in the midst of a thriving community. 75% of the units were unoccupied. People, you couldn't tell who was living in which apartment, where there was a site of safety versus where this undercover police force was occupying the territory. It was sort of arbitrary and chaotic where you could be safe, and her daily life was characterized by having to move through a neighborhood where you never knew who was behind which vacant apartment. But she never expected that the police would be the perpetrators of such violence assault. The first night, they took her keys, forced her into a working elevator, destroyed her property, moved down the hall, arrested her 19-year-old son after seriously battering him for 30 minutes, forced her into a bathroom in her apartment, forced her to remove all of her clothes, 3 of them with their guns drawn, lie down on the floor, spread her legs, and effectively do an internal cavity search on herself while they watched. During the vicious attacks that lasted for over 3 months, there were constant attempts to put drugs on her, to take her money. At one point, they rearrested the son. She had another son who was on probation and parole, so very vulnerable to the forces of law enforcement. The Chicago police officer unit who targeted her never produced search warrants, never explained why they were there, and never read her constitutional rights, etc. They would sort of enter and leave her space abruptly, always violently, humiliating and degrading her. This case was ultimately taken up by a legal clinic in the city of Chicago and settled out of court. But what was important is that the series of assaults that she experienced from the police completely paralleled the experiences that she had of sexual violence from people in her neighborhood. She was gang raped twice. The community was in turmoil about this destruction of public housing. There were tense neighborhood relationships. It was an ideal backdrop for targeting of a woman like Ms. B. When the case was settled out of court, they didn't lose their jobs, the 5 of them. She was moved into protective custody, further isolated, and in the end lost the money from the settlement to an abusive partner who effectively used his emotional control and manipulation to leave her as poor and destitute as ever. So these are cases that illustrate what happens in disadvantaged, low-income African-American communities in cities like Chicago. But it's important, I want to give one more example of a case, because it's important to remember that that isn't the only place that the anti-prison movement and the anti-violence against women movement have not done our work well. So I'm going to ask you to come with me for a minute to New York City, to Greenwich Village, which is, as many of you know, a neighborhood with a liberal reputation that's earned through activism and resistance by members of the black GLBT community in the late 1960s. Today, the image of Greenwich Village, of course, is one of openness and tolerance. And it was there that 4 proud lesbian-identified black women, young women, were enjoying the rare opportunity to feel open and as if their gayness would be accepted, so they thought. They walked past a young man selling DVDs on a card table, and he sexually propositioned them in insulting ways, offered all sorts of degrading comments toward them. I will fuck you straight, while grabbing his genitals, for example. Embarrassed, shocked, angry, the girls crossed the street. A security camera sort of followed this abusive episode. He continued to harass them, followed them down the street. When they turned eventually and confronted the abuser, a heated argument started. There were eyewitnesses to this account. 2 of the eyewitnesses, who were young men, white men, jumped in to protect, allegedly to protect the girls. At some point, the original perpetrator, the harasser, was stabbed. It's not exactly clear by different accounts who the assailant was, who used the knife to stab him, but there is no good forensic evidence to link the knife injury to the young women. In fact, some eyewitnesses confirmed, in fact, one of the young men himself said he was the one who did it. Thanks. So the aggressor, who was a young African-American man reported to be a part-time student at an elite university in Greenwich Village, was never charged with a crime. All 4 of the women were arrested, all of them went to trial, and despite the widespread media coverage, the mainstream gay rights organizations and groups associated with attending trials on behalf of African-American people, high-profile trials, who, particularly young men, were also absent. There's a lot more to say about how the media portrayed this event, but what's important to note is that surrounding their victimization was a law and order agenda, new law and order agenda, anti-gay agenda, anti-loitering ordinances in gentrified neighborhoods in New York. Was a recommitment of wealthy real estate developers to clean out Greenwich Village and sell apartments to wealthy people. A question about hate crime legislation and who's advocating for what. Is it gay marriage or safety for young lesbian girls walking in the streets of New York? And all kinds of portrayal of this event as a lesbian wolf pack. And the consequences of the media coverage, I mean, that was actually used in part of the deliberations. The consequences of this are not only what has happened to these 4 young women, all of whom have served time, but what the city was allowed to believe about itself, and the silence of the anti-violence movement, and the silence of the anti-prison movement, and the silence of the gay rights movement on this issue. It should be noted in Ms. B's case and in Tanya's case, they reached out to anti-violence groups in the city of Chicago, and no one responded. There has been an attempt to organize around the New Jersey 4, as the case in New York is called, and it has not been taken up as important work for the movements that I find myself involved in and often depending on. So to conclude, here I am, a black feminist, anti-violence activist, moved by these individual stories to try to do something different, but deeply troubled by the lack of allies that I find to understand that this is the problem of violence against women in the year 2010. And it's not a problem that intersectionality can't solve. It's a problem that we have chosen, a set of problems that we have chosen not to include in our work. It's too complicated to talk about sexuality when we're focusing on gender violence. It's too complicated to talk about women when we're doing anti-prison work. As a result, these 6 women, who of course are only examples of the hundreds of thousands of other women who are similarly situated, are left unattended to by both our intervention, but I would say more importantly, our political praxis. I think as scholars, activists committed to critical race theory and intersectionality, this is our next challenge. That is to hold our social movements accountable for a serious engagement with these issues. Thank you.
Good morning. It's great to be here. I won't tell you, it's kind of cliche, I won't tell you what the temperature was when I left Minneapolis yesterday, but it's wonderful to be here. I recently published, I think it just came out last week, an article that I'd like to talk a little bit about today called Relocation Revisited: Sex Trafficking of Native Women in the United States. For the last few years, I have tried to find intersections between federal Indian law as a scholarly field and anti-violence work. And very few folks have really looked at this issue, and I think that part of the challenge has been that most of the federal Indian law scholarship, even that is very, very critical of American imperialism, fails to discuss the issues pertaining to Native women and how Native women have been impacted by colonization, Christianization, assimilation, and many of the isms that we talk about when we talk about tribal nations in the United States. So I've been trying to take a look at how the different eras of federal Indian law policy in the United States over the last 200 plus years have facilitated widespread gender violence in tribal communities. And part of the challenge is that most of federal Indian law scholarship is couched in terms of government sovereignty from the tribal perspective and land loss in terms of the Indian Wars and relocation, etc. So I seek to revisit some of those different eras of federal Indian law policy from a perspective of Native women and a perspective of victims of violence, and how federal Indian law and the policies that support it have facilitated and institutionalized sexual violence in tribal communities. I began by taking a look at the high rate of sexual assault and domestic violence in the lives of Native women. And these statistics largely were developed by the federal government itself. So about this was 1999, the Bureau of Justice Statistics, part of the Department of Justice, released some of its crime victimization data, which was astounding in the sense that nobody had really ever articulated, other than Native women, the high rate of violence in their communities and the high rate of sexual violence in particular. So what I've tried to do with this most recent piece is to look not just at the rates of sexual violence in isolation in terms of individual experiences of Native women, but to look at how the policies of the United States have facilitated what I think meets the definition, any definition, legal or otherwise, of sex trafficking. And so I look at kind of four different categories of federal Indian law policy and how they intersect with sexual violence. And those are enslavement, exploitation, exportation, and relocation. So I like to walk through just a little bit about what I found in my paper. And I have to say, too, that most of what I did with this most recent piece is a historical look. In the United States, we have very little in terms of contemporary data or scholarship, although just last summer, the Minnesota Indian Women's Resource Center issued a report called Shattered Hearts, the lives of sex-trafficked Native women in the state of Minnesota and the Twin Cities in particular. There actually has been more literature developed in Canada regarding the high rates of Native women in sex work, and in sex work in particular that Native women want to leave and are unable to. So I back up all the way to Columbus, of course, where it all begins, and note, I mean, it's a cliche, right, that all of the colonization can be traced back to that. But I particularly took a look at the gendered nature of contact and the context in which Columbus and his counterparts viewed Native women, and certainly from the very beginning it was a gender dynamic in the sense that Native women were raped from the minute the boats landed. And this is not something that was a covert activity. It was indeed documented by the very folks who perpetrated that violence. The enslavement then continued, I would say, arguably until the early 1900s in terms of a legal structure which actually allowed Europeans to buy and sell Native people for the purposes of labor or sex. And this to me is just absolutely consistent with the United States' own contemporary definition of human trafficking. And I know that in the last administration, in the Bush administration, there was so much focus on human trafficking as a third world problem, or a problem that originates in undeveloped countries where women are seen as subservient and therefore sold into slavery, which completely dismisses the American government's own role in perpetuating this for hundreds of years. And Native women have been the primary targets. So when I looked at enslavement, there's been less, obviously much less analysis of the ramifications of enslavement in Indian communities. In fact, many people don't often realize that Native people were subject to enslavement for most of the settlement period of the United States. And inherent in any kind of enslavement is sexual exploitation, right? Because if you're owned by another human being, you don't have the right to reject sex from that person who owns you. And so inherent in the whole legal structure of slavery is this sexual exploitation. The second piece that I look at is the exploitation that came along with colonial rule. In particular, the military occupation, and I'm talking about not just American, but the predecessor colonial militaries, the Spanish, the French, and the English, that again did not criminalize sexual contact with or sexual violence committed against Indian women, and thus it became commonplace. It was never against the law to rape a Native woman. So you couple the enslavement and the accompanying exploitation, and the result is that Native women were commodities to be bought and sold and used for both labor and sex. Moving on to the more kind of, I think, more conceptually relevant discussion of exportation or removal. There has been a great deal of literature looking at things like the Trail of Tears, the Western expansion, the Manifest Destiny, but oftentimes, again, Native women are not really visible in that rhetoric. It's really about the movement of tribal nations as governments, about land loss in terms of male conceptions of what land means in terms of this is your reservation and this reservation has been diminished. And what I've tried to do is identify, and it's very difficult to go back and find specific examples of sexual servitude in these Trail of Tears stories, because oftentimes it was not documented. And the victims who were being raped as they were being transported against their will across thousands of miles, there was no privilege of being able to report that or to document it, because it was really a matter of life or death. And so I found a few passages in which we can identify that during the Trail of Tears, the Long Walk, etc., that there were there was widespread sexual victimization going on. Again, like I said, it's very difficult to find these stories. I did find one small passage from Creek woman, my tribe, from oral history that had been written down after being passed down through generations regarding the Trail of Tears, and this woman reporting that as the weeks went by, as this migration, this forced migration went by, that at night the soldiers would take the young girls, about 12 or 13 years old, remove them from their community where they were camping, rape them, and then return them to their community. The other passage that I wanted to note was the Amanda story, which came out of Oregon. In July of 2009, a hiking trail in Oregon was formally named in remembrance of a brutal journey experienced by a Coos woman known only as Amanda. And the story of the trail's namesake, Amanda, was the account of an 1864 account when the U.S. cavalry was rounding up all of the Indians in Oregon and taking them to a reservation, that this particular woman was captured and she was separated from her 11-year-old child and had to walk along the jagged rocks of the Oregon coast, and that her feet left a trail of blood in her wake. And at that time, again, in that time period in Oregon's history, even the murder of Indians was, for all intents and purposes, legal. And so you can understand if murder is allowed and not prosecuted, that rape and sexual assault would certainly not be either. The other, in terms of movement, in terms of trafficking, when we take about trafficking and kind of the lay idea of it is that you're moving a person from one place to another, is the boarding school era in which Native children were essentially kidnapped from their communities for the purposes of furthering assimilation efforts by the federal government and churches who wanted to kill the Indian but save the man. And again, we have the kill the Indian but save the woman. That part never seems to come up. But the widespread abduction of Native children from reservations, I think, can be categorized as a form of trafficking. And the boarding school era in more recent years is being understood finally to be synonymous with sexual abuse on a grand scale. It's stories from survivors of these boarding schools where they were told not to be Indian anymore. They were told not to speak their language, not to practice their spiritual ways, not to look Indian. Were also havens of pedophilia and sexual violence. And so I think that does also meet even the contemporary United States definition of human trafficking. Relocation is kind of my final look at the history of how federal Indian law and sexual violence intersect. And this period of time began in the 1940s. In the 1940s, in 1940, only about 7% of Native people lived in urban areas. And in 1943, the Bureau of Indian Affairs launched a comprehensive program to transition Indian people from the reservations to the cities. And in 1952, they actually called it the Voluntary Relocation Program. And the person who was tasked with overseeing that program was Dylan Meyer, who was the civilian in charge of the Japanese-American internment camps during the 1940s, which is probably why they called it the Voluntary Relocation Program, because they'd gotten some bad press at that point. By 1960, over 30,000 Indians had been relocated, and in 1980, the Bureau formally suspended the project, but the migration has continued. In 1990, the census indicated that nearly 60% of Native people reside in urban areas today. And in my research, I discovered that it was in this time period between the 1940s and the 1960s that predators really began to use Native women in organized crime rings in sex work, in prostitution. And the social scientists that documented this dynamic actually blamed Indian culture for this dynamic. And one expert in in the 1960s said that the social ills that Indians experienced in urban locations were because they were incapable of comprehending the basic instrumental values of modern urban industrial society. And some of the other social scientists, like for instance in Alaska in 1963, a male social scientist wrote that for the young Native females, drinking seems to help them overcome sexual inhibitions, and this is crucial to their popularity with many of the young whites. In 1970, an article entitled Promiscuity and Prostitution in Urbanized Indian Communities provides more insight into the mainstream kind of white male perspective about prostituted Native women. And he said that these Native prostitutes were difficult to study because they're habitual liars and chronic alcoholics. And when trying to understand why there were Native women engaged in sex work, the authors claimed that it was random factors and forces that were responsible for Native women entering prostitution, which of course ignores the whole role of the whole story of how these Native women ended up in the cities anyway. So today, there's simply, it's an invisible problem. The Native women working in prostitution in the United States is a very underdeveloped subject of study. One passage that I did find was that of the of the women in the city of Minneapolis on probation for prostitution, 24% of the women in Minneapolis on probation for prostitution-related offenses are Native. And Native women only make up about 2% of the population of the city in general. So we have this overrepresentation. And like I said, the studies that have been done in Canada are really illuminating. A study conducted in 2000, of course, and the reason I'm saying this is because the colonial history in Canada is very parallel to that in the United States. A study conducted in 2000 estimated that 70% of the street prostitutes working in the most dangerous and lowest paying tracts in downtown Eastside Vancouver were Aboriginal women under the age of 26, and most are mothers. In Winnipeg, one advocate reported that hundreds of teen and preteen girls as young as 8 and averaging about 13 are working the streets. Even more are abused behind closed doors, with about 80% of child prostitution taking places in gang houses and trick pads. An estimated 70% of these girls were Aboriginal. And when you talk, and again, it's very difficult to get data about the experiences of these girls and young women because they simply are so marginalized that no one even talks to them. But there was a study done on HIV-positive Native women prostitutes in Winnipeg, and they did cite to relocation as being one of the main legacies that they live with every day. Relocation through government apprehension or running away resulted from the perceived inadequate or abusive parenting that thrived with an environment permeated with absence and loss. And so this is just a preliminary piece with just some kind of basic foundational historical analysis that I hope that I can build on and that other scholars can build on as well, as we try to really understand the legacy of federal Indian law, not just from a tribal government perspective, but from individual Native women's experiences. And in some communities, you know, when I've talked to Native women who are victims of this kind of predation, you say it's not just me, it was my mother and my grandmother and my great-grandmother and my great-great-great-grandmother. We've all experienced this. So I think it behooves scholars of federal Indian law to expand their notion of what colonial violence really means. Thanks.
Hello, I'm Tanya Hernandez, and it's a great honor to be here, and thank you for the invitation. Okay. As we all know, intersectionality theory has made a tremendous contribution towards understanding how women of color can be differently situated regarding legal issues of race and gender vis-a-vis men of color and white women. But what sometimes can be missing in the contemporary applications of intersectionality theory is Kimberly Crenshaw's foundational insight that the theory also has the potential to reveal how intersectional law reform benefits larger society. Crenshaw specifically stated in Demarginalizing the Intersection that, quote, if efforts instead began with addressing the needs and problems of those who are most disadvantaged, and with restructuring and remaking the world where necessary, then others who are singularly disadvantaged would also benefit. In that light, I would like to revisit the 1986 case of Meritor Savings Bank versus Vincent to illustrate how intersectionality theory not only benefits women of color, but our broader society as well, or at least has the potential to. Let me get to that. Meritor is not traditionally viewed as an intersectional case, but an application of the theory elucidates a great deal about the court's analysis. First, just a few words about the case itself. In Meritor, the Supreme Court not only recognized for the very first time that sexual harassment was a legal claim that could be actionable, but also held that hostile environment sexual harassment constitutes a Title VII sex discrimination claim, just as quid pro quo sexual harassment does. Right? So not only what seems like the very obvious situation of someone says, you have sex with me, or you lose your job, that's quid pro quo, that the judges could immediately understand. But Meritor was noteworthy because it also recognized that being in a workplace where you are constantly sexualized, even if your job isn't contingent on performing sexual services, that too is sexual harassment. So the case is quite noteworthy. All right. In addition to being a landmark sexual harassment case, Meritor is also well known for rejecting the idea that if a plaintiff voluntarily, in as much as no one physically forced her to, engage in physical contact with the harasser, that the plaintiff could not proceed with her claim. That the court rejected. The court instead recognized that inherently hierarchical relationships between a supervisor and a subordinate might inaccurately appear voluntary, like the word yes might have been said, right? But that doesn't make it. Okay, you see where I'm going. Okay. So the Supreme Court got this with a lot of help from Catherine McKinnon and others, right? So they recognized that these hierarchical relationships, that while they might appear voluntary, that consent, this legal understanding of consent, would not be an appropriate barometer for assessing a claim of sexual harassment. So as a result, the Supreme Court required that a plaintiff instead show that harassment was unwelcome, regardless of whether there was consent. Okay. So Meritor, a remarkable case. Now to the intersectionality analysis. The case involved a black woman plaintiff publicly asserting that her black supervisor had sexually harassed her. And in fact, women of color have figured prominently in the development of sexual harassment law and policy. African American women brought most of the early precedent-setting sexual harassment cases, including the first successful Title VII case in federal district court, in a federal court of appeals, in the first successful cases involving harassment of a student, harassment by a coworker as opposed to by a supervisor. Right? Black women have been quite present. But despite the central role of women of color in the evolution of sexual harassment law, few people know about the racial context of these cases. No discussion of race appears in the court opinions themselves. And discussion of race has also been largely absent from the legal discourse and commentary surrounding these cases. There are some exceptions, but let's move on. The landmark case of Meritor represents a prime example of this racial silencing. In Meritor, none of the judicial opinions at any level, district court, court of appeals, Supreme Court, mention both that Michelle Vincent and her harassment were African American, despite the presence of the information in the court record. So this is not one of those, the litigators weren't thinking about intersectionality. No, the litigators told them. Okay. The paucity of race-based analysis in the legal discourse surrounding Meritor is particularly striking, right? Given the importance of the case, the development of sexual harassment law, and the significant involvement of women of color in the early sexual harassment movement. Moreover, the social science literature demonstrates that racial identity often shapes a woman's experience of sexual harassment. This impact occurs because both racial and gender discrimination interweave in the experience of sexual harassment of women of color. Unlike white women, women of color who are sexually harassed typically describe workplace interactions where racially and sexually charged comments are simultaneously made regarding their clothing, their bodies, and their conduct. While my remarks today focus on the particularities of African American women because of Michelle Vincent's status as an African American woman in this case that I'm focusing on, I also want to note that other women of color share many of the same victimization patterns as African American women. Moreover, women of color who are also linguistic minorities or lack U.S. citizenship can be particularly vulnerable to being sexually harassed, right, both as racial discrimination and as gender discrimination. Now, that Michelle Vincent, a black woman, was the plaintiff in this landmark sexual harassment case has not automatically protected women of color from being marginalized in the legal theory of sexual harassment. By ignoring the potential salience of race in sex discrimination law, the courts have created a doctrine that consistently obscures the experiences of women of color and thereby veils the use of racial stereotypes in the development of sexual harassment jurisprudence. Doctrinally, the absence of a race-conscious Supreme Court analysis in Meritor itself results in a problematic jurisprudential conceptualization of welcomeness. When do you welcome sexual harassment? What do you have to show that it's unwelcome? To be precise, the Supreme Court's decision to make a complainant's sexually provocative speech or dress, those are their words, relevant to a finding of sexual harassment embeds unconscious historical presumptions about the wantonness of black women into the legal doctrine. The examination of the attire of black women, such as Michelle Vincent, dovetails with stereotypic notions of the sexual availability of black women. By ignoring the race of the plaintiff, the Supreme Court was able to overlook the significance of racial stereotypes that pervade the question of appropriate evidence of welcomeness. The insistence on a colorblind assessment in the Supreme Court analysis obstructed recognition of the speech and dress portion of the welcomeness assessment as a problematic racial construct. For them, it was all about gender. As a result, all sexual harassment plaintiffs are now unfairly burdened with an inquiry into whether their apparel and speech welcomed sexual advances. And this evidence may be used to eviscerate their claims of sexual harassment. The legal record before the Supreme Court did contain information about the racial identities of Michelle Vincent and her harasser and the analytical relevance of race. Vincent's brief before the Supreme Court that was submitted by her trial attorney Patricia Berry and feminist scholar Catherine McKinnon explicitly stated the following: all too often, it is black women like Ms. Vincent who have been specifically victimized by the invidious stereotype of being scandalous and lewd women, perhaps targeting them to would-be perpetrators. This is not to say that this is a case of race discrimination only, right? Because they didn't want to get into that problem. They're just trying to get sexual harassment recognized. The court says, oh, you're saying it's a race case, not a gender case? Bye-bye. So I can, I put that one in brackets. But it is to say that rather that minority race aggravates one's vulnerability as a woman by reducing one's options and undermining one's credibility and social worth. In the context of such beliefs which animate this case, a picture can be painted which destroys the victim's ability to complain of sexual violation, such that sex acts can be inflicted upon her and nothing will be done about it. In addition, an amicus curiae brief submitted by the Working Women's Institute explained, black women and women who are members of other minority groups are especially vulnerable to sexual harassment, due largely to their inferior economic position. Black women may also be more vulnerable because of their unique place in American history. One unfortunate legacy of slavery, where black women were considered the property of white men and were sexually exploited, is the stereotype of black women as sexually available, sexually promiscuous, and unprotected by black men. In this case, the black man was her aggressor. As in the present case, black women are also harassed by black men, in part because attitudes towards black women in the culture as a whole have been shaped by those of the dominant group, white men. The fact that other members of the protected group join in the harassment does not make the harassment any less illegal. All of that was in the court record. Sociological research confirms that black women and other women of color are more vulnerable to sexual harassment. Yet, the Supreme Court decision failed to even acknowledge this important data, as well as failing to engage in any race-conscious analysis of sexual harassment. Doctrinally, the absence of a race-conscious Supreme Court analysis results in a problematic jurisprudential conceptualization of welcomeness in relation to sexual harassment law. The opinion specifically states the following: while voluntariness in the sense of consent is not a defense to such a claim of sexual harassment, it does not follow that a complainant's sexually provocative speech or dress is irrelevant as a matter of law in determining whether he or she found particular sexual advances unwelcome. To the contrary, such evidence is obviously relevant. Okay? So to be precise, the Supreme Court's decision to make a complainant's, as they say, sexually provocative speech or dress relevant to a finding of sexual harassment embeds unconscious historical presumptions about the wantonness of black women into the legal doctrine. The examination of the attire of black women is completely erased in the silence of the opinion, and yet ever present throughout all the implicit stereotypes that are used. A psychological study of black working women found that the sexual harassment black women experience commonly involves racially charged comments regarding their clothing, in addition to reliance upon racialized sexual stereotypes. A double standard existed for black women in the study, in which their clothing was more closely scrutinized in a racially sexualized manner, and certain styles of dress presumably associated with black women were deemed inappropriate or offensive in the workplace. For instance, when one of the study participants changed into a red dress after work in preparation for a dinner date with her husband, a white colleague said to her, "You look like you're getting ready to stand on the corner," implying that she looked like a prostitute. Another participant who wore tan slacks, like khaki slacks, and a loose-fitting button-down shirt was chastised at work for dressing too sexy. I guess because when it's on a black woman, there's something sexy about it. Even shoes take on a racial meaning when they're worn by black women. This is a... I know stuff gets heavy, so we have to have a little laughter, right? Here's a quote from one of the study participants. "I applied for a job, and this guy says to me, 'I'm sorry, you got on the wrong shoes, and you just wouldn't fit this job. You wouldn't fit this job. Come back when you get better shoes.' I looked around at the white girl that was working there, and she had on sandals, flip-flops. And I knew what he meant about me." In short, while there is no single dress style attributed to black women, right? This is not about culture, or presumed culture, right? So there's no single dress style attributed to black women or other women of color. The mere fact that it is a black woman or woman of color wearing it can subject the apparel to a characterization as overly sexual and offensive to the workplace. So by ignoring the race of the plaintiff in the Meritor case, the Supreme Court was able to overlook the significance of these racial stereotypes that pervade the question of appropriate evidence of welcomeness. The insistence on a colorblind assessment in the case obstructed any recognition, right, of the speech and dress portion, right, of the evidentiary structure as problematic. As a result, all sexual harassment plaintiffs are now unfairly burdened with this inquiry into whether how they wore their clothes was saying yes, even while their mouth was saying no. Right? Although framed as evidence of welcomeness, the focus on the plaintiff's clothes or lifestyle often seems more intended to invoke the timeless dichotomy of good, bad girl, virgin whore, painting a woman as so degraded as to be impervious to offense. Because the inquiry is often intrusive, irrelevant, and damaging, it discourages legitimate sexual harassment claims. The application of this problematic understanding of unwelcomeness and sexual harassment doctrine reduces the incentive for a victim to come forward. For these women who manage to muster the wherewithal to file a complaint, a review of the cases indicates that courts repeatedly apply the unwelcomeness requirement in a manner that encourages stereotypical thinking about how a plaintiff asked for with her clothes. So in conclusion, the story of Michelle Vinson shows how her case validated the concept of sexual harassment, hooray, while at the same time shaping the law of sexual harassment in problematic ways. The court developed the evidentiary standards for the sexual harassment unwelcomeness concept in Meritor by implicitly relying upon these long-standing racialized stereotypes of black women as promiscuous. By ignoring race in the case, the court rendered invisible the racialized construction embedded in its analysis, and thereby insulated it from challenge and reform. If you can't see it, you can't talk about it, you can't fix it. So now all sexual harassment plaintiffs of all colors continue to endure this unfortunate legacy. But intersectionality helps us to see it, to see the commonality, and perhaps now to try to pave a way to reform that empowers women of all colors. Thank you very much.
Good morning, Aria. Well, it's a bit late for this. Is my microphone switched on, or should I?
Just move it closer.
Move it closer. Okay. If you don't mind, I will remain seated because I think with my jet lag it will be a bit easier to get through this. So closer still? Okay. Now I'm from Europe, definitely. From the 3 different countries that I'm affiliated with, one that I was born in, Belgium, and 2 that I'm working in and living in, Austria and the Netherlands. And I will try to put my examples also mostly to the European context and see where that brings us. I'm a political scientist and I'm a feminist. And my goal is to comprehend why, when, and how different inequalities get in each other's way as groups of people, such as social movements or political parties or specialists or academics or civil servants or activists, attempt to reduce or to do away with inequality. It's not that I think that those people who try to change inequality are solely responsible for abolishing inequality. It remains the case that it's capitalism and patriarchy that is causing it. But I think it's especially harsh for me to endure that those movements that actually try to do something against it would themselves actually reproduce inequality. So that's why I focus on that part. So not to say that it's the movements that are causing all this. And I try to be clear about that. And we know that the scientific community, on initiative of Kim Crenshaw, dubbed this phenomenon of different interfering inequalities, intersectionality. And we've seen an expansion, a really exponential growth of publications on this topic that I will draw on and try to categorize the different ways in which strategies have been outlined to address intersectional inequalities and abolish them. And it's very tentative, but it's meant to enable a discussion about it. Do you see other categories than I do? I'm doing this because also there is a high demand for guides that could point out how to properly build laws and policies to fight inequality that do address intersectionality. And I think the room is packed with people who know even much more than I do, so I look forward to feedback on that. And the way I looked at it, I find that current academic discussions and political practices suggest 4 different political and policy approaches to best address interference between inequalities, to best address intersectionality. And the first one that I identify is a reactive approach. Reactive in the sense of exposing what is wrong, pointing out that we have strategies to address interfering inequalities that are counterproductive and that lead to stigmatization or to marginalization of targeted groups. It's an approach that calls for mapping the margins. Where are they? What are they doing? To whom? As well as a focus on the marginalization processes and mechanisms. So this approach pleads to expose those processes of marginalizations. And we've heard numerous examples of this in not only in the legal categories, in laws, in policies, but also in implementation processes. How is it enacted in practice? And I will give one example from the Netherlands, from my own research, actually, research I did with Connie Roggevand to debunk also the idea that the Netherlands would be an egalitarian or society, which increasingly we've had 4 right-wing governments in a row and facing another one coming potentially, so we're not. Connie and me did a research of both gender equality policy and what's called in that period minority policy, integration policy, migration policy between 1995 and 2005. And we found that the case of migrant women had become an emblematic policy problem. And finally, some category gets attention, one could think. This attention, however, was stigmatizing and marginalizing. And we showed in this analysis that the Dutch government, in the process of giving attention to migrant women in the Netherlands, had created and fixed in law a new categorical pair, the migrant population versus the native Dutch, or in terms of the Dutch policies, the allochthonous ones who are not from here, are not us, and the autochthonous, or you could say native, white people. The paradox was that it was the left parties that had the attention for migrant women be put on the political agenda, but the right-wing parties who ran away with it and decided what the content of these policies would be. So the new Dutch regulations that have been made in that process for transnational marriage, for instance, place women in a vulnerable, dependent position, and also the whole policy making more and more culturalizes and individualizes the problem that migrant women face. And in fact, the European Court of Human Rights has just said that the Dutch government is violating human rights in that case. Because they have different policies, they have different obligations for Dutch citizens and for citizens from migrant origin. Who have to have a higher income in order to be able to marry. You have to be 21 instead of 18 in order to be able to marry. So it's a serious violation of human rights. The government in this period basically tells these allochthonous women, who might be Dutch citizens in their passport, by the way, that it is their duty to emancipate from their problematic culture, which is a euphemism for Islamic culture in the Netherlands. And this has started a racialization process in the Netherlands that falsely positions gender equality as a core value of Dutch society, for which you can blame Islamic groups for not having this core value. And what at first was a question of religion and national background has become more and more a question of race, with the Muslim label as the defining quality of that race. And I think that's in line with David Goldberg's work, that this is like a specific European form of race construction, also in a historical sense. I don't know if you're familiar with his work, but he says that the figure of the Muslim, alongside with that of the Jew, has historically bookended modern Europe's explicit historical anxieties about blackness. And although the government officially says in its rhetoric that it wants to discourage negative branding of allochthonous people, the government itself is the one that is constructing these categories and making different demands of their different categories of citizens. So to expose the government's counterproductive efforts as well as those political viewpoints that contribute to inequality, I think is an important part of any effective intervention towards intersectional politics. And I think academics should and could contribute to any such process. And in fact, I think it's this strategy of exposing marginalization is called for not only considering laws and policies, but also considering the science that we're supposed to use and develop. And yesterday I was at a presentation of Mary Louise, who similarly addressed this issue that it's not only laws and policies that make this, it's also science that makes these categories, and it should be integral part of this strategy of exposing intersectional bias. Now, of course, this first approach is a very important one, but it is strong on diagnosis, but weak on prognosis, weak on telling you what you could do in order to abolish this inequality. Still, if you look at it, it is something that can be done unless the environment becomes absolutely hostile. I mean, you can do it under right-wing governments. You will not land any assignment from the governments the moment you start doing that. But you can do it. They will not fire you at university for that. They might delay your tenure or something. So I think the three other approaches that I identified have in common that they call for what you could do. It's three different approaches to demarginalize, going a step further than just diagnosing what the problem is and how it is created. And I find three. The first one is a pragmatic approach, and it's one that I find both in Europe but also in the US. A pragmatic approach that suggests that complex interferences of inequalities do not necessarily require complex new policy instruments or measures. It calls for undoing these effects of marginalization by applying intersectionality to existing legal instruments. So, of course, it's a precondition that there are already some that you could apply. And I find the work of Margaret Satterthwaite, I don't know if you're familiar with her work, very interesting in this respect. She did work on migrant female domestic workers and made a long list of the problems that they can potentially face, and it's a really, really long list. It goes from exploitative terms of work, restrictions on the freedom of movement, labor market discrimination, dangerous and degrading working conditions, gender-based violence in the workplace, gendered forms of racism and xenophobia, restrictions on their ability to organize for their rights. And what she does is she places a list of existing human rights treaties side by side with these problems and sees which of these problems can be addressed by already existing legal instruments. What she does is she stretches those instruments that are already there in order to show how, in the case of victims of this type of intersectional discrimination, you could do something to improve their lives. So she looks at CEDAW, she looks at the Convention on Racial Discrimination, she looks at the International Covenant on Civil and Political Rights, on the Migrant Workers Convention. And I think it's an interesting approach. And I found it interesting because at the European level, the European Union has called for an integrated approach to multiple discrimination. So as a result of that, a lot of European Union member states are reorganizing their equality legal infrastructure to have a different one that somehow integrates attention for different inequalities. And they look at it in different ways. And two researchers in a project that I'm leading, the Queen Project, looked at different instruments that are currently still present. Europe is like a big laboratory of different arrangements for this. So the Netherlands have one committee for all discriminations on all grounds, and Belgium has a separate one for gender and puts the other one in a box. And in both cases, the two researchers, Sophie Lauwers and Saskia Martens, showed that actually the exact form of the legal measures and infrastructure is not what makes the difference. What makes the difference is the presence of practitioners who try to stretch those measures. So this is why I think it's important to look at this first approach, a pragmatic one. Of course, you could wonder whether this is only a short-term strategy that brings like some relief, maybe. Is it also something that could bring change? I think it could be. I think by stretching legal categories and legal infrastructure, you can also induce further change. But there I'm not a legal specialist, so you know much more about this, I think. The third approach, to demarginalize, is a more substantial structural approach. One that says that actually policymaking should be aware that it's creating societal structures that fix inequalities of various natures. And these structures are almost always structures that categorize people, that fix inequalities, that make distinctions between citizens with certain obligations, other obligations, certain duties, certain rights, certain positions. And there is a lot of, I already give the example for the Netherlands of different standards when you can marry. Should you be 18 or 21? Can you have social benefits? Or do you have to have a minimum income? In the case of the Netherlands, that is 120% of the minimum wage. So, but you can also say states are categorizing people that they can have assisted reproduction if they're heterosexual and married, or also if they're lesbian, or if they're lesbian but only if they're married. Or they can make any type of decision there, and they do. And in doing so, they create structures. And they create hospitals that do that, and doctors that do that. And so you can only address inequality fully if you would have an approach that scrutinizes the whole of society for this making of distinctions and creating differences between people. And I'm a specialist on gender mainstreaming. I know that for American audiences, this is a very alien concept. But in the European setting, it's an official strategy adopted by the European Union. Even it's an official strategy adopted by the Beijing Platform for Action. And we were all hoping maybe that Obama would sign CEDAW and do a number of other things. Hasn't happened yet, could still happen. But I think this strategy, if you look at it, it requires a state to really subscribe to the political goal of abolishing inequalities. Such a strategy cannot work if there is not at least a rhetorical commitment to this. Otherwise you have no room to develop anything that is like inequality mainstreaming. But this is the case in the European Union and its member states. So for us this is a basic thing to try and further develop what is called gender mainstreaming into a procedure that scrutinizes laws, new laws and policy making as to how they could potentially contribute to further inequality or to reduce or abolish it. And to do so not only on the lines of gender inequality, but on all inequalities and on their intersections. So that and there is a current problem to that. If you look at the European Union level, at this moment there is uneven protection across different inequality strands. The gender inequality has a very extensive set of policy strategies and measures where there is something like gender mainstreamings that at least rhetorically tell you to change the structures of society and to scrutinize policies before you make them. But it's only about gender inequality in some way related to employment or vocational training. If you look at racial inequality, that has a broader protection also to goods and services and to education. But it's mainly about discrimination of individual citizens. Is not protected at a deeper level. And if you look at sexual orientation, it has then a little bit of the one and a little bit of the other. So it's very, very uneven, and class is never completely there. class is there only in anti-poverty policies and not as an inequality axis in itself, which is a problem if you want to address it structurally. Still, I think it's to be done. And with my first strategy, I said this is not only something that should be done to laws and policy making, it's also something that should be done to science. And I think also this structural approach is something that should be done by academics when they apply science. I just sent in, and that's why I look a bit tired, probably not only the jet lag, an application for a research grant, where one of the elements is research on the gendered interface of employment and care in European countries, so in all the EU 27. Now, the standard understanding that there is different gendered welfare states mainly looks at leave regulations, so maternity, paternity, parental leave, and childcare facilities. In this project, I want to add the regulations on domestic work, because if you don't do that, the ethnicized character of such arrangements will never become visible. And many European states have different minimum wages for domestic work. And this is always the black or ethnicized communities that are suffering from that. So if you look at gendered welfare states only through childcare as available to parents or leave regulations, you will never see that. Okay. The last approach that I want to mention, I identify as a process approach, a procedural approach, not focusing on the structures to change, but on how to actually shape the political process and who should be given a voice in this process. So this is about creating space for marginalized groups to have voice in decision making, for movements to be able to articulate their demands for equality and social justice, in a context that is not made to trigger territorial reflexes between these movements. And this is something that has to do with the nature of our democracies. And mainly, I think, a lot of the work that has been done there has been done in the context of work on deliberative democracy. So I will be short about that. I think it's always going to be a problem. I'm a bit of a Nancy Fraser person who says, you cannot really have deliberative democracy in a context of inequality. So maybe you should develop forms of what Chantal Mouffe would call agonistic struggle to be able to realize radical democracy. So yeah, that's a bit short, but that's what I wanted to say about this. And the other side is what I said, that it's the context also that structures the way that movements can engage in coalitions. And if I look at the work that's been done on cross-movement coalitions, I think oftentimes the movements sometimes seem to be blamed for doing the wrong thing. Of course, they're doing that. That is not my point. My point is that they're doing that also in a context that facilitates them doing that, and that hinders them coming across that. So as a political scientist, I want to have a closer look at what it is that triggers competition between movements. And if the European Union is having a system where they favor an umbrella organization for each of their inequality strands, and if they have uneven protection across the inequality strands, this is not going to bring any coalition building further. This is one of the things where I'm not an activist, but I try to bring my knowledge to the field. So I've been to a number of roundtables between these umbrella organizations at the European level. There you can see that the European Organization Against Racism is quite relaxed in thinking we have this broad protection, but also they're very open to say, yeah, of course, and the lesbians and the women, and let's do something. ILGA Europe, which is the gay and lesbian organization, is in a difficult position because they have not so much protection. So they have to cooperate. That's their only means. We have so many homophobic states in the European Union. Lithuania just adopted a law that forbids to give information on homosexuality to anyone who's under 18. Means you cannot even have a helpline. They will have to take that law back, but for the moment they haven't. So it's a problem. Yeah. Okay. So there, I think it's. We'll just say that there is at the moment an awareness within these movements at the European level that they should and could cooperate. And I will give one example of that, which was a roundtable on sexual orientation, gender identity, and gender inequality, where the European Women's Lobby, ILGA Europe, Transgender Europe, the Intersex Movement, and Amnesty International, and some people from the European Commission were sitting together and realized that actually, if you focus on genital mutilation, it's not only the women's lobby who's busy with that, but the intersex people too. Actually, if you focus on stereotyping as a problem of gender inequality, then the gender categories are a problem, and not only for the women, but for the trans people too. And actually, if you focus on gender-based violence, and you would forget the trans people, what are you doing? Mm-hmm. So, and that was a very constructive meeting that I think will lead to further improvements in what this movement can work together. And that's one.
Hello. I'm so happy to be here at this very exciting conference, and I too wanted to thank Kim for inviting me and all the organizers for all the hard work putting together this fantastic conference. As a practitioner, I've addressed intersectionality by focusing on the ways in which poor women of color are particularly vulnerable to government interference in the exercise of their fundamental rights. One example is a case we currently have pending that challenges the banning policy in place at the Housing Authority of the City of Annapolis, HACA. I'm going to show a short video, which hopefully, given that this session has been going on a while, will keep your attention. Just a short video that presents the voices of some of our clients and tells a little bit about the case. Before I do that, I just wanted to give you a little bit of background. The Housing Authority puts various people on this list, some who have criminal convictions or juvenile adjudications, and others who were arrested but were never prosecuted or convicted of any offense. Once someone is on the list, he or she is not allowed on HACA property, even if invited by a resident of the housing complex, someone who lives there. So as a result, our clients are not allowed to invite members of their families to come to their homes to help care for their children or for elderly relatives, or to come and visit with family at holidays or other important gatherings, such as after the funeral of a loved one. You'll hear from one of our clients, Delonda Moses, who lived in Annapolis Public Housing with her family from the time she was 7 years old until recently. She and her boyfriend, James Alexander, had a baby girl named Mariah last year. And because James is on the Housing Authority's banned list, he was not permitted to visit Delonda while she was pregnant. During her pregnancy, Delonda suffered from several health problems, but nevertheless, HACA told Delonda's mother that she and Delonda would be evicted if James came to their home to help her. So as a result, James had to pick Delonda up from school in order to take her to doctor's appointments. After Mariah was born, Delonda was forbidden from inviting James into her home to help feed and care for their daughter because James is on the banned list. And although Delonda had lived with her mother and her sister in public housing for most of her life, she was so distressed by the fact that James could not come to her home to help care for her and Mariah that she ultimately moved out of public housing and off HACA property, away from her own mother and sister and support system, so that James can help raise the baby and be part of their family. Another client who you'll hear from is Glenda Smith, and she has been raising her great-grandson Rico since her granddaughter Kira was incarcerated following a juvenile offense. When Kira got out of prison, and to this day, she is banned from the HACA property and therefore is not allowed to come and move back in with her own son and grandmother, or even to come and visit them in their home. As these stories illustrate, the Public Housing Authority's banning policy forced women to choose between their right to affordable housing and their right to raise their families with the full participation of other family members, including their own children, parents, grandparents, and the fathers of their children. So we'll watch the video.
More than 500 people are on the ban list at the NF.
James Alexander was banned from seeing his daughter in her mother's home based on a juvenile arrest in which he was never prosecuted or convicted. So the baby's mother, Yolanda Moses, had a choice: raise her daughter without a father or move away from the support of her family in public housing to be with James. The ban wouldn't even let James pick up a baby bottle.
And he rushed up to the porch, picked up the bottles, and he was coming off, and the police saw him, and he was arrested for trespassing. He'd only been on the property for a minute, and it was completely innocent. He was just trying to help his daughter. But that just led to a criminal arrest, and now he's being prosecuted.
Yeah, I'm trying to be a good father, and I don't know, I just try to stay on track.
It's important to me that Jane get involved because I want her to have a father in her life. You know, everybody don't have fathers in their life and that's like that. And I want to get a family. That's why we kept the baby so we can be a family, not to get separated.
So the reality is very far from the abstract goal, which is a laudable one, of making public housing safer. It just ends up making things more difficult for these women who are trying to raise their children and do so with the support of their families.
It's had a lot of effect on Rico because he wants to be with his mom, he wants to be with me. So if I could have both of them here together, you know, it would help me to deal with having my family together, because I feel the banning law is not good, because I feel the law is the law. If you break the law, you serve your time, that's it. But to break the family down because of a mistake somebody made, it's just not fair to the family, because you're tearing families apart, you're putting them in the street, the kids can't come see their parents, you know, or grandparents. It's really hard. Would you want someone coming to your home and tell you what to do, how to raise your kids, or tell your child that your child is out in the cold, or your grandchild, you can't come to my house, or if you're having a family gathering, you can't come because of that? To me, this is their property, but the families, they don't own us. You know what I'm saying? They own the area here, and we're living here, and I respect that. But you can't get into personal people, families like that. I'll have my grandchildren back home with me. I'll stop having my silent tears at night, wondering why, you know, we're human beings. Why do you think you can come and tell me my grandchild can't come here, or if I have another child can't come see me because they're banned? You know, that's my child. That's part of me. Well, I think with Rico being with his mom, he would feel better. Once that happened, we can be a family again.
Thanks. I wanted to show this video and let the clients speak for themselves a bit. I think that this case and the video illustrates well the concept of intersectionality, the phrase coined by Kim Crenshaw 20 years ago. Dominant notions of discrimination under U.S. civil rights law have tended to focus on a single aspect of identity, such as race or gender. This unitary inquiry, however, fails to adequately address those who exist at the intersection of marginalized identities. As we've been talking about, and as Professor Crenshaw posited in her 1989 article, Demarginalizing the Intersection of Race and Sex, an intersectionality analysis, or recognition of these multiple concurrent identities, is necessary to address the marginalization of such groups. The intersectional experience, as Professor Crenshaw has explained, is greater than the sum of its parts. That is, black women do not just experience a simple equation of racism plus sexism. Rather, their experience is unique and requires an entirely new framework for analysis. And as you've been hearing, this concept of intersectionality has been applied now to a variety of fields, including employment discrimination, sexual harassment, violence against women, and many others. Yolanda Moses and Glenda Smith, two of our clients in the HACA litigation, suffer from such intersectional discrimination and marginalization. Because they are poor women of color, the government interferes in the exercise of their fundamental rights in ways that it would never dream of doing to white upper middle class families. Structural racism and gender oppression have led to a class of people in this country who are disproportionately poor and dependent on the government for their basic needs, including housing, healthcare, and subsistence benefits. In this case, I'm talking about black mothers. As a result, and because the United States views housing, healthcare, and food as private commodities to be purchased on the so-called free market, rather than as human rights that all people should be guaranteed, poor women of color must access these basic needs through government programs such as public housing, Medicaid, and TANF. And because poor women of color utilize these government programs rather than purchasing these products on the open market, the government feels entitled to interfere in these women's most private decisions, including when and how to create and raise one's family. In our Annapolis case, because Delonda lives in public housing, the government feels entitled to tell her that she may not invite the father of her baby into her home to help care for him and raise him. Can you imagine the government telling a white middle-class mother living in, say, Pacific Palisades, California, that she may not invite the father of her baby into her home to help care for the child? If the government tried to do that, voters in this country would call it totalitarianism. They would not stand for it. But here, because Delonda is poor, African American, and a woman, the government and many constituents believe that her fundamental right to choose how to raise her family and whom to invite into her home is not her choice alone. That is an illustration of the intersectional challenges faced in accessing housing. Policies such as HACA's banned list and many other policies and laws enacted as part of the so-called war on drugs often impact women and families in ways that legislators and executive branch officials, as well as the general public, haven't envisioned. Women have been among the frontline victims in the war on drugs, including policies such as mandatory minimums, prosecution of low-level drug offenses, and increased use of accomplice liability and conspiracy charges to convict and imprison those with relationships to drug dealers. The number of women with convictions, especially low-level drug-related convictions, has skyrocketed in recent years. Over the past 2 decades, the number of women in prison increased at a rate nearly double the rate of men. And women of color are disproportionately affected. African American women are more than 3 times as likely as white women to be incarcerated in prison or jail, and Hispanic women are 69% more likely. The majority of incarcerated women are parents, and most were the primary caretakers of their children prior to being incarcerated. In contrast, while many men in prison are also parents, few were the primary caretaker prior to their incarceration. When women or men leave prison, they face a host of barriers to obtaining housing as well as other basic needs. Women are also affected by these policies that target members of their families who were involved in the criminal justice system. So as you've seen, women who live in public housing may be evicted if a member of their household engages in criminal activity, or in this case is prohibited from coming on the property and does so anyway. The barriers to housing for people with criminal records are widespread. HUD reports that ethnic or racial minorities make up 69% of public housing households, and women lead 77% of those households. They are women-headed households. So when women are coming out of prison, this is a major impediment. One report observes that as most of the incarcerated mothers come from impoverished communities, it is likely that many of their friends and relatives live in public housing complexes. As a result, women with children who are released from prison are unable to return to the support networks that would help them most effectively re-enter society. These banning lists are in place in many public housing authorities across the country. We've seen them in New York, Boston, Washington State, Vermont, Illinois, St. Paul, Jacksonville, West Virginia, really numerous cities throughout the country. And as I mentioned earlier, housing is not the only government program providing for basic needs in which women of color suffer from intersectional discrimination. Because women bear children, and as a result of our society's imposed gender roles, women continue to bear primary responsibility for raising the next generation. And because people of color in this country suffer from a history of structural racism that has impacted where they live, what education they receive, and what jobs they are able to obtain, women of color in this country, as in many places around the world, are disproportionately poor. As a result, women of color are disproportionately dependent on the government to satisfy their basic needs, as I've mentioned, including public housing, TANF, Medicaid. And the government, through these programs, then interferes in their ability to decide how to raise their own families and conduct their lives. So we've seen that here with the banning policies, the government tells women whom they can invite into their homes. We've also seen the U.S. government telling poor women of color that they cannot have abortions through restrictions on Medicaid funding, and that they cannot have another child through TANF and welfare exclusion policies. So I think that one helpful way out of some of this is to use a human rights frame in approaching these issues. Under a human rights frame, housing is viewed as a right, not just a privilege for those who can afford it. Under a human rights frame, the government has an affirmative obligation to exercise due diligence to ensure the protection of human rights, not merely a negative obligation not to interfere. A human rights frame can also be helpful in overcoming some of the limitations of U.S. constitutional and statutory civil rights law, under which analyses of discrimination focus on one protected class rather than address the exponential forms of discrimination faced by individuals who fall into more than one subordinated class. When the focus is on the right at stake, such as housing, and that right exists for all humans, a claimant need not rely on or fit into a box of one or another of these characteristics. A human rights frame also, in contrast to U.S. constitutional law, focuses on disparate impact as well as intentional discrimination, as do some of the civil rights statutes. I think that when we focus the public's attention on the ways in which government policies impact women and children, we may have a greater potential to change people's hearts and minds, particularly with regard to these policies that have been adopted as part of the war on drugs. The impact on women and families has often been overlooked. And by making these invisible harms visible, we may be able to shift the debate. Other challenges to public housing authority banning policies didn't focus on the ways in which these policies tear families apart. And by highlighting this harm in the public education that we've done around our lawsuit, we have made decision makers, legislators, and public housing authority managers think differently about the policy. Although sometimes focusing on women can bring out more stereotype-based reactions in opponents, I think that often even the paternalism, even conservatives, because of their paternalistic views, may be brought around to want to protect women, and therefore we may be able to change some of these policies in ways that then will benefit all people who are impacted, not only women. So to close, I believe that using an intersectional analysis and applying a human rights frame can help us better understand the problems suffered by poor women of color and their families, and think more creatively about solutions. And as an advocate, I'm trying to integrate this complex thinking into the advocacy that we do, and to encourage other advocates and practitioners to do the same. Thanks.
We did begin a bit late, but that doesn't make lunch any closer. I do think that we ought to take just a few minutes now, first to thank our wonderful panelists for these stimulating presentations. And we can take just a few questions if there are people in the audience here who would like to pose them for our panelists. Yes? Yes, please. I think you may need to come to the mic, though.
I was wondering if one of the things that could tie together a lot of the presentations that have happened is how the state is willing to move people around. I think it's sort of striking where sort of in capitalism there's an emphasis where capital is supposed to freely flow throughout the world, but it seems like there's an increased emphasis on people's movements being limited, either through native people being forced to go into urban spaces, or say sex offenders being forced to move away from schools, or people not being able to go into particular areas like public housing. Do you think that that type of sort of spatial analysis could benefit sort of linking the work that is for part of the panel?
Any of our panelists want to tackle that one? Please, Mieke.
Maybe I didn't seem to talk about this, right? But I think one of the things that came up in the roundtable between gender, sexual orientation, and gender identity is the inability of trans people to travel because of the gender categories in our passports, and the time it takes in many, many countries to change that. So this is one of the ways in which these distinctions also work on other categories, because it's currently not, a lot of trans people are currently not able to move freely within even the European Union, even if the free movement of all is at the height of European Union construction.
Anyone else? Okay. Our next question?
Yeah, just quickly for Lenora Lapidus. I was wondering if you've worked with sort of politicians and policymakers in pointing out the contradictions of policies such as welfare reform and TANF, which has emphasized personal responsibility and family integrity in a sense, you know, and in terms of what you're talking about, this is really encouraging the breakup of families. So, you know, how do they sort of talk about those contradictions, or do they recognize these things?
Yeah, I think that, you know, that is part of what our public education is about. That's why we make films like this, to kind of get the message out there more. And I do think there is a hypocrisy and a contradiction. And I also think in this context, and in a lot of the war on drugs policies, that those impacts simply have not been thought about. And so the more that we can highlight the ways in which the policies really do impact families and tear them apart, I think that that is helpful. But certainly when you look at the range of ways in which government interferes in poor women's lives, poor women of color's lives, there are a lot of those contradictions.
Mm-hmm. Can I just add one quick thing to that? And I've learned a lot about this from your work, that it's not only the individual policies, but it's the ways the policies themselves contradict each other. Mm-hmm. So you can't live in public housing until you have an address, but you can't get an address until you have a place to live, and you can't have a place to live till you get a job, but you're barred from certain employment. So it's almost, it's the individual policies are bad enough, but it's the multitude of negative impacts that come from the web of public policy that it's almost, you almost can't deny that policymakers are sort of talking to each other almost intentionally to have one policy contradict each other that leads to this revolving door between communities and jails.
Anyone else? Okay. Our next question.
My question's for Sarah Deer. My name's Sarah Hunt. I'm from the Kwakwaka'wakw First Nation from Canada. And I just really appreciated you kind of tracing those links to the various aspects of trafficking. And I do work on sexual exploitation of Indigenous youth and trafficking in BC. I guess one of the questions I have is that of course, human trafficking of Indigenous girls is one of many kind of forms of sexual violence or types of violence in our communities. And one of the more difficult things to trace through law or in other ways is kind of the normalization of violence in our communities. And I think it's really useful to look at that migration to cities, but part of the, because there's a lot of attention now being paid to urbanization and the violence that's really more evident because of the presence of Aboriginal women, as you say, on the street or street-level sex work, is that the types of exploitation happening in our own communities and rural areas is really invisibilized through that because the eye is now in these urban centers. So I guess that's one of the things that we're doing, or that we're doing in BC is trying to turn that lens as well to say that there's this continuum of violence happening. It's not just in urban areas where it's really apparent, but it's in our homes. It's because of the internalization of colonial violence and the way that systemically on reserve it's being maintained as well through those systems. So I guess maybe if you wanted to speak to kind of that continuum a bit.
Yeah, I think that, when I've traveled to Indian reservations and talked to folks about trafficking and sex work, people don't really use the term prostitution so much on reservations, but they do talk about survival sex. And they do talk about, exchanging sex for money or drugs, but they don't think of it as prostitution. Again, kind of the stereotype of a prostitute in the United States is somebody who's working on the street corner in an urban setting. But certainly sexual exploitation happens in rural areas, and it is even more invisible, I think, in that context. So thank you for raising that.
Okay. I think we only have time for one or two more. Is that we have? Okay, please. We're going to end by 12:35. I'm under instructions.
So I want to express my gratitude for all that you shared today and the knowledge. I took a lot of notes. So my question was for everybody. So we talked about the institutional dynamics that maintain the intersectional vulnerabilities of women and deny the recognition and the effective intervention of ending that violence. But perhaps you guys can mention something about what structures maintain and reproduce the behavior and the violence that occurs by the perpetrators and, certainly the state. But so what is it? So it's that women are being victimized and killed and raped, and that is an event that happens in conjunction with the other half, right? So the perpetrators are committing this violence. And I want to hear if you have any ideas about, perhaps Lenora, Lapidus, the idea of using human rights as the framework to rehumanize the women, and the women could, that continue to be outside of the parameters of the protection of the law. It could be immigrants, or it could be people that are not conforming to the gender expectations. It could be women in prisons. So how do we bring the human rights framework to humanize all peoples so that we can start to address the perpetrators' reproduction of this idea that committing violence against other people is acceptable?
I mean, I'll quickly respond. Another way in which we've used international human rights strategies, specifically in the domestic violence case, is a case that some of you probably have heard about, Jessica Gonzalez versus Castle Rock. And this was a case that a woman had a domestic violence order of protection, and notwithstanding that, the police failed to go after her ex-husband when he kidnapped their 3 children from the front yard. The case went all the way up to the Supreme Court, and the Supreme Court denied any remedy. We filed a petition in the Inter-American Commission on Human Rights, relying on human rights law which again, as I mentioned earlier, puts a more affirmative obligation on the government not simply to not interfere, but rather to provide for the realization of rights. So in this case, to provide actual safety from violence. And that case is making its way through the Inter-American Commission, and we're hoping to get, we've already gotten good rulings so far along the way, but hoping to get a final ruling that will really lay out how strong the international human rights guarantees are to ensure safety from violence. And just one quick thing, the case has also then given the client, Jessica Gonzalez, an opportunity to speak for herself and tell her own story, which is one of the things that I think is so important in the human rights approach, that individuals more often have those opportunities to speak for themselves and tell their own stories.
Thank you. I do think we're going to have to close now. I again want to thank our panelists and ask you to remain seated, please, because you're going to be provided with some instructions about lunch. So thank you all.